So, ladies and gentlemen, dear colleagues, of course, first of all, I would like to congratulate for such professional preparation, like always, of the conference and the entire project of research group. Thank you also for inviting me and give me a chance to present my general reflection about topic, content of the right to parental responsibility and the activities on non-governmental organization in Poland. And a natural question arises, why did I choose this topic? First thought is, parental responsibility is linked to the parents. However, this does not mean that the child is isolated in the relation with other entities. This power is not absolute. In some circumstances, other entities may also support, interfere, and sometimes even perform some of the activities corresponding to the content of natural parental authority due to the best interest of the child. At first, such interference was reserved almost exclusively for state institutions. But look at this. In the modern world, it is worth noting the dynamic development on non-governmental activities. And Poland is not exception. They carry out a wide range of activities, including those that may relate explicitly or implicitly to the sphere of parental responsibility. Thus, the subject is topical from different perspectives, and it will become more and more complex. I could say this: as a citizen, I have a right to raise my children according to my beliefs. As an attorney, I have the right to represent non-governmental organizations within their statutory activities. As an academic teacher, I have the right to analyze these norms and organize them. But as a father, I have constant and very real problem how to raise my children well. But Winston Churchill said, it is easier to rule a whole country than raise 4 children. Ladies and gentlemen, my presentation will consist of the following parts, except for this introduction. The first point, an outline of the legal basis for the activities of non-governmental organization in Poland. The second one, the welfare of the child and assistance to the family as a goal of the activities of non-governmental organization. And the last one, activities of the public benefit organization in the perspective of exercising parental authority. And at the very end, the final conclusions. The first point. In the Polish legal system, the activities of non-governmental organization in the broad sense are complex in terms of sources of law. Firstly, therefore, it is worth presenting an outline of these sources. In terms of the legal basis for the activities of non-governmental organization, several branches of law can be distinguished, in particular religious law or administrative law. Bearing in mind the historical aspect, it should be pointed out that charity activities aimed at the welfare of children have been carried out in Poland for centuries by church organization units. These units were not called NGOs in Poland. This concept is quite new in the Polish legal system. However, in a broad sense, these units can be classified into the category while respecting their individuality. This is important in terms of the relationship between parental authority and the activities of this type of organizational units, which in their activities are primarily guided by religious premises. In this case, the relationship of such units to parental authority is even more complex than in the case of non-governmental organization of secular nature. the activity of church organizational units was severely restricted during the communist period and sometimes even banned. Despite this, these units ran various types of shelters and single mothers' home. It was only at the end of the system in 1989 that laws were passed which guaranteed organizational units of church legal persons to conduct extensive charity and care activities. In the Polish legal system, charity and care activities are currently guaranteed both generally and individuality. In addition to charity and care activities, in the perspective of parental authority, it is worth pointing to educational and upbringing activities, as well as numerous schools and other educational institutions. As in the case of charity, such activity has been carried out in Poland for countries. Moving on the next branch of law, it is worth pointing out that it was only in 2003 that the Act on Public Benefit Activities and Voluntary Work entered into force in the Polish legal system. The Act includes a definition of non-governmental organization. Also, in the case of administrative law, attention should be paid to the activities of these units in the field of education in the context of parental authority. On the other hand, it should be noted that NGOs can also create educational institution on their own. If such an institution is established by these units of religious association, there is a notable increase in the level of complexity of legal sources regulating the activity of such an institution. For example, in the field of teaching in accordance with Christian values. So, activities of these units are not limited to the administrative law or religious law. Although these are the basic sources of law, they are not exhaustive. For example, copyright law, civil law, or maybe even criminal law. And partial conclusion of this point. With the above in mind, it can be concluded that the activities of non-governmental organization sensu largo are regulated by many branches of law and at different levels in the hierarchy sources of law. Therefore, a complex interpretation of the sources of law regulating the activities of this organization should be applied first in order to refer it later to the relationship with the sources of law regulating parental authority. In both cases, it may also be necessary to refer to constitutional axiology due to the need to analyze a given value in the perspective of their hierarchy. However, it should be remembered that individual values may also be in a superiority relationship. It may even turn out the hierarchical collision rule may not be sufficient. An individual approach to particular legal issue arising from the relationship between the sources of law regulating the activities of non-governmental organization and the exercise of parental authority is recommended. Point number 2. As mentioned before, the notion of activity of this organization is very broad. Considering units of religious association, it should be noted that their care for well-being of the child results not only from caring for the good of man and the common good. In their case, the premises of religious nature are also important. In the case of public benefit activities that can be carried out by non-governmental organizations, it is worth pointing to the so-called sphere of public tasks. This sphere currently includes 41 tasks listed in a closed catalog. Some of these tasks are directly or indirectly related to the welfare of child and help for the family. For example, the first category includes tasks such as social assistance, including assistance to families and people in a difficult life situation, and equal opportunities for these families and people, supporting the family and the foster care system, or activities for the benefit of the family, motherhood, parenthood, dissemination, and protection of children's rights. The second category is definitely broader. It includes, for example, providing free legal assistance, charity, activity for the integration of foreigners, and the others. Partial conclusion of this point. The activity of non-governmental organization in Poland has an extremely wide spectrum. Its goals also include helping children and families. The statutory activities of this organization may also embrace such assistance. However, it is extremely important in the Polish legal system for such assistance to be included in the statutes and a given organization and others document regulating its activities. The choice of statutory goals is usually unilateral, and only a registered non-governmental organization can enter into a relationship with parents. Sometimes, however, parents themselves can create NGO and, for example, to run an educational institution. Point number 3. The activities of NGOs within the framework of the above-mentioned legal basis and specific statutory activities are not always neutral from the perspective of exercising parental authority. It is worth remembering that the constitutional norm requires statutory conditions and a final court decision to limit or deprive parental rights. Often, there are various types of relationship between this activity and the exercise of parental authority by parents. And several situations can be distinguished in these regards. One of the criteria may be the degree in interference with parental authority. In this respect, we can distinguish the activities of NGOs which may consist in informing, supporting, and even replacing parental authority. Even the very activity of NGOs consisting in carrying out information activities towards both parents and, above all, children can be problematic. Such activity may fall within the sphere of public tasks and may be financed from public or non-public funds. For example, an NGO may conduct road safety training for children. Such informing activity is performed not only in educational or cultural institutions where it is easier for parents to control their children's activities. However, it is much more difficult also in the juridical sense for parents to control the activities of NGO that are conducted of other forums, such as a social networking sites in relation to their child. And the next degree of interference may be activity of non-governmental organizations consisting in supporting parental authority. From the legal perspective, it is also worth noting that free legal assistance is provided to parents. Such assistance is provided in Poland by many NGOs, which in this respect are financed from public or non-public funds. The most far-reaching it is possibility of even replacing parents as part of the activities of NGOs. For example, such activity may consist in running an orphanage. In this case, obtaining consent is not necessary. However, the NGO must operate on the basis of a clear legal basis and a relevant court order. The second criterion for dividing the activities of NGOs in relation to parental authority is the criterion of voluntary or coercive action on the part of parents. In the first case, the information activities of NGOs carried out with the consent of parent can be indicated. More complicated is the activity of NGOs in relation to parental authority in the absence of parental consent. And partial conclusion. Therefore, it can be conducted that relationship between the activities of NGOs and the exercise of parental authority is quite complex. In relationship in question, different degrees can be distinguished which give rise to specific legal effect. If the activity of NGO requires parental consent in some cases, the activity of this NGO without obtaining such consent results in the civil law liability and in some cases even criminal. On the other hand, it's also possible to imagine a situation in the Polish legal system in which the activity of NGOs indirectly based on the relevant legal title does not require parental consent and may interfere with the exercise of parental authority. And the final conclusion. The relationship between the activities of NGOs and exercise of parental authority is a topical complex issue. Moreover, due to the development of NGOs within the sphere of public tasks, this issue may become even more complex. There is an increasing direct and indirect influence of NGOs on the upbringing and education of a person, which is not indifferent from the perspective of parental authority. Although parental authority is particularly rooted in constitutional axiology and has a natural character, it is not absolute. The freedom to conduct public benefit activities by non-governmental organization is also not as such nature. And maybe the last conclusion, compliance with this principle should be, the lege ferenda be also required in the case of the activities of NGOs, also in other spheres where this activity may concern a child, in particular in the context of the cyberspace. And at the very, very end, dear colleagues, thank you for your cooperation in this year. Thank you for your attention.